everyone. I think we have everything back.
This is a public service.
All right, the next case is case number 22-11247, parcel 42230206013, Michael Henry and Katherine Henry. The alleged violation at 33 Cypress Circle is no building permit issued in the Land Development Code, Chapter 1, Article 3, pavers installed without obtaining permit. And we'll proceed with the city.
My name is Janet Bruce, neighborhood. Yeah, I'm sorry, Your Honor. The city would, and going back to the previous case, we had one of our city planners who's also going to testify, and we also have some neighbors who are to testify.
With the other case,
Yes.
did we have anyone to testify in the first case that I missed, or just the second case?
The second case.
Okay, and
Oh, okay.
the second case as to storage containers.
Yes, Your Honor.
Okay.
Yeah.
We're going to get someone who wanted to testify.
I was just going to check the main office to see if anybody was there.
Oh, okay. She just went over. But Sarah, we're going to call you.
Right now?
Yep.
Okay.
Are we ready?
Yes, we are.
We're still on case number 2, which is 22-112246. The city has presented its case, and I've heard arguments from the respondent, and the city has some individuals that they want to testify. Who is that?
Yes, we have one of our city planners. And if I may, Your Honor, just briefly, just kind of following the respondent has testified to, and we have a fence case and a paper case, and in those cases, we've asked the respondents to obtain a permit, for those, because fences and pavers are something that can be approved. It may be modification of height or setback, or you can't, have too much impervious area, those sort of things, but they are subject to approval. Storage containers such as this, cargo containers, are not going to be subject to approval in a residential neighborhood, and that's why we're going to call the city planner to explain that.
Okay, you come forward here. And would you be sworn?
Of course. Good morning. My name is Sarah Cushing.
Please raise your right hand. Do you swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do. Again, good morning. My name is Sarah Cushing. I'm with the Planning Department with the City of Ormond Beach. I'm here and available for any questions that you may have.
Sarah, if you could explain, you've looked at the photos of the cargo containers, and could you explain why or why not these would be permitted in the city of Ormond Beach?
Of course.
If someone applied for a permit.
Yes, definitely. So all of these types of shipping containers, whether they're a Connex container or a temporary pod container, all of those accessory structures are outlined in section 2-50 of the Land Development Code. Specifically item number X with outdoor storage. Item number 3 specifically states that personal on-site storage structures shall be limited to situations where a person or business is moving to a new location. This storage unit shall not be placed on a period for over 30 days. So this particular structure that we see in the images above are for temporary purposes only and subject to only be used for moving purposes. If somebody by chance needs longer than that, there would need to be cause to show that it's actually for moving purposes. As we heard earlier, it sounds though as if this is more of a long-term storage, and this would be more of the accessory structure for a shed or a detached garage. Sheds are accessory structures that are outlined in section 2-50N. I'm sorry, that's fences. Section 2-50D, that outlines sheds, as you mentioned, sheds, utility structures, playhouses, and gazebos, more specifically. Sheds are anything that are built according to Florida Building Code standards, and if it's under 150 square feet, it can be 7.5 feet from the rear and side property lines, assuming that there's no platted easements. If by chance this structure is over 150 square feet, then it has to meet the principal setbacks of that particular zoning district. The subject property is located within the R4 zoning district. It is identified as a duplex in this zoning district, and the rear yard setback for an accessory structure over 150 square feet would be 20 feet in the rear and 20 feet on the side. So had anybody come in to talk about options for sheds, detached garages. The whole purpose of the planning department is to go over these regulations. To answer any questions in depth, look at some type of survey or aerial and go over what reasonable locations could be on this property. We understand that this particular neighborhood, along with other historical neighborhoods in the community, may not have garages. So having that detached garage for an accessory structure for storage purposes is something that would be encouraged rather than a Connex trailer. Thank you.
Thank you very much.
Any questions?
I certainly do. You mentioned that with, I believe you mentioned accessory structures, that the setback would be 20 feet on a side.
Yes, ma'am. For the particular zoning district that your subject property is located in, it's the R4 zoning district. This information can also be found on the website, but I'd be happy to send it to you. R4 zoning district is a single family cluster and townhouse zoning district, and there's a number of different types of single family options in here. This particular one in Bryan Eleanor is a duplex and subject to the setbacks outlined in the duplex column.
So, do you know where it would say the 20 feet?
In that zoning district, it's section 2-17 of the R4 zoning district outlined in the city's land development code. Under item 9 is where you have your setbacks, and item 9A all the way through 9E outline setbacks of that zoning district. And again, you would be looking at the column for duplex.
So it wouldn't be 20 feet in total, so it could be 8 feet on one side and 12 feet on another side? You're saying it's 20 feet per side setback?
Correct. If it was a single family home, in this particular zoning district, the 8 foot on any one side, a cumulative total of 20 would be applicable, but because this is a duplex, the duplex, again, is 20 on the side and 20 in the rear.
Are you familiar with, you obviously testified that you've seen the pictures. Have you also then looked at the aerial view that was submitted, or just familiar with the government's property records, the property assessor's records that show the aerial view of the property?
I have not specifically looked at the aerials of this particular property, but I'm familiar with the neighborhood. And if you had a survey, I could be able to help provide better guidance and direction.
So does it sound about right to say that these parcels are no bigger than 1/4 of an acre?
Until I see a survey with the measurements, I wouldn't be able to give you that answer.
Okay, so if you did have a property that was no bigger than 1/4 of an acre, where you have, say, 88 feet total frontage, are you saying it would still be physically possible to end up placing any kind of other accessory structure other than dead in the center of the home?
It would be dependent, one, on the size of the accessory structure. So if the accessory structure is over 150 square feet, then it has to meet the principal setback requirements. If it's under 150 square feet, it shed accessory structure, which can be 7.5 feet to the side and 7.5 feet to the rear. Assuming that there's no drainage or utility easements within that, no accessory structures outside of a fence can be placed within these particular type of easements. But until I know exactly the size and the location and have a survey, I wouldn't really be able to tell you reasonably what would be permissible or what would be the most accurate or anything of that standard.
So what would you say is supposed to be the procedure if you have people that call on a property? I don't know if you're familiar with how hot the market was, at least in 2021. If property came out that day, you had to put an offer in that day. So if you have a realtor or a prospective buyer on a property, a specific property, reaching out and saying, hey, 33 Cypress Circle, can you put a garage here? What if it's, quite frankly, I don't even know who it would be directed to at that point, but if you have somebody from the city replying back and saying, certainly you could do that, it just has to be 25 feet back from the front property lines, etc. There's no offer of looking at the survey, there's no offer of going into any further detail. In fact, it takes several emails back and forth just to get a copy of what section of the code would even apply. You mentioned earlier that it's an offer, one of the purposes of your office or maybe your position is to be able to sit down with residents and explain some of those things. So how is it that that's available, but yet the city doesn't communicate that? How would a resident know that other than reaching out and saying, hey, this is specifically what we'd like to do at this specific property? How can we make it happen?
Of course, so those are very good questions I'm happy to help give guidance on. So everybody has its own zoning district, every home does. And it's really up to the due diligence of the property owner to reach out. I can't come up to you and say, hey, you have to do X, Y, or Z. But we get emails all the time, we get phone calls all the time, and we have people come in person all the time. That's what our office deals with, is handling these inquiries and providing them with the necessary tools that they need to make the decision that's best for them and their property, so that they can move forward with the appropriate permits if necessary. So if somebody were to call and say, hey, 33 Cypress Circle, I have, the interest in wanting to put this particular shed here, I would do exactly what you just stated. I would get their email contact information, so that way I can send them an email with the regulations that reference the particular question in play, such as sheds. Oftentimes I attach the detached garage standards, because once you go over an accessory structure over 150 square feet, that automatically goes into the definition of detached garage. So I kind of explain that in that written email. When they provide the address, then that can help me provide the zoning district regulation. And then I usually typically give them guidance of how to navigate the city's website as well. So that way, if you're looking at this property temporarily, or you're looking at another property, you have the tools necessary to do that research on your own if it's after hours and you're looking for an immediate response.
That sounds great. So if a realtor such as ours, when we purchased this property, were to reach out and email the city, and quite frankly, I don't remember who it would have been, but let's say it went to somebody else just in the general, city office, whatever city hall, right? Are they supposed to funnel those types of questions to you or your department in order to give the correct information?
Yes, ma'am. It depends on what email that you're sending it to. If you're sending it to just the general city email, whether that's upstairs in our city clerk's office, then they would definitely forward it to the appropriate department. For instance, our permit office, our permit technicians have their own individual emails, but we also have our general email inbox with BP Online. And all of the general permit questions go there, and then the permit technicians will review those and forward them to the appropriate departments. Because, for instance, somebody could be sending a general email asking about setbacks for a property to BP Online. They would send that to the planning department rather than the building department. But if somebody's asking questions about Florida building code and safety requirements, wind load speeds, and the like, they wouldn't forward that to me, they would forward that to our building department for verification for that particular.
So is there some sort of procedure in place then when you are not, when your department is not given, I can't imagine I was not given the information that you mentioned. I was not given an offer to look at a survey, to go over anything. I was actually given information that was incorrect. One of the things was they specifically said has to be the 8 and 12. If you have 8 feet from the property line, that's fine as long as you have 12, specifically for the property that we have with the zoning that exists today. And so if you're telling me now that the information we were given in the email, which of course I don't have ready access to right now because I didn't know it would come up, but if you're telling me that that is incorrect and that it has to be 20 on each side, with a property that's only 80 feet wide, that's basically putting it in the middle of a property, is there some sort of catch-all procedure that would help people be able to know that they're getting the right information, or be able to have somebody give it a more thorough, how would somebody in my position who went through a realtor, who contacted the city and got an answer, but apparently got the wrong one, what would there be for a remedy to make sure that we're getting the right information?
I understand your question. I would encourage you as the property owner to do your due diligence above and beyond what the realtor's due diligence is. Because while they're going to be reaching out and asking these questions for you, how they interpret the information that's given to them is one thing, you know.
And I appreciate that. There was no interpretation. She forwarded on the email to me. In fact, I think I was just copied, so I think I got directly the response from the city. So there was no interpretation from the realtor whatsoever. I'm specifically talking about information that came directly from the city. So is there really not any kind of mechanism or procedure to make sure that either the correct people or the correct information is being provided then when residents do due diligence and reach out before even putting an offer in on a property to make sure that they can do some of those things?
Again, it's the same thing, reaching out to staff and providing for that clarification. If you feel that the direction and clarification that you got from one staff member may or may not be accurate, then you can reach out to others. But it's the same information that you're going to get from one staff member to the next. We are a very small group of staff members that works closely with our land development code and the zoning districts, and understanding this difference of setbacks depending on the type of structure within that zoning district itself really helps give that particular direction to the inquirer.
So,
okay, this is getting to the point where it's not assisting me in trying to make my decision. So if you'll wind up your questions of this witness.
Yep. So you testified about that 250, section 250 of the LDC categorizes what I have as temporary only, and then it can only be used for moving. What in there, where in the code does it say anything about that those can only be viewed as or defined as temporary and then used only for moving?
So 2-50 is for accessory structures as a whole, all of the different types of accessory structures. 2-50X is for outdoor storages, specifically item number 3, so 2-50X3 talks about on-site storage structures, which this would fall under that category.
Is that defined anywhere in the code?
So you can go under temporary structures, you can go under our definitions, I believe it's 1-22, which has those different definitions in there. But those are that's typically the standard protocol of using these Connex trailers or pods as moving purposes only. If you're talking about long-term storage, then we would be going into an accessory structure like a shed, if it's 150 square feet or under.
I was just asking about what the definition was, because I guess my confusion is that, hopefully you can clarify this. 250DD3 that you have mentioned that talks about sheds and utility structures.
I was quoting 250X3.
Just now, but earlier you talked about 250DD that is specifically about sheds.
Yes, ma'am.
You said it requires that any structure or shed over 150 square feet shall be considered a garage and must meet the principal building setbacks, which you mentioned earlier.
Yes,
however, you also just recently mentioned LDC section 1-22 to look at the definitions, and 1-22 doesn't actually talk about the temporary or connex or any of the things that you said are in there. They're nowhere in there, but what is in there is it talks about utility structures, but that they are only defined as accessory structures that do not exceed 150 square feet. So this being larger than 150 square feet, it's not covered as a utility structure under that part of the code. So
if that's the case and it's exceeding 150 square feet, it automatically gets defined as a detached garage and has to abide by the detached garage accessory structure standards.
and where does it say that in there?
So specifically 2-50 double D, 3A, for the purposes of this section, any utility structure or shed over 150 square feet shall be considered a garage.
Okay, where are you reading from on that specific?
2-50 double D,
Okay.
and
Right.
it's for the area requirements. And then you go into a definition of a garage, and specifically a detached garage, and there's certain standards required for detached garages, one of which are meeting the principal structure setbacks.
Okay, thank you for your testimony. We're gonna move on.
Okay, thank you, sir.
I'm sorry, may I ask just a couple
Yes.
questions, I'll be quick. Does the Florida Building Code address use of cargo shipping containers for residential purpose?
So that's a good question. So our office deals with the planning and the land development code side of the regulations. Florida Building Code standards are above and beyond. It's what the state requires all of the structures to meet certain requirements for safety. The building department can answer those specific questions, but it's my understanding from previous conversations with some of their staff that these particular structures aren't regulated under Florida Building Code standards and therefore wouldn't be able to pass a permit with their department.
Okay, and one last question. The respondent mentioned whether or not there was a mechanism for a homeowner to know whether or not there would be, a structure would be permitted on the property. Wouldn't a mechanism be the application of, one of them being an application of a permit, so you can review that before they expend the time and money to bring something onto the property?
That's correct, yes. So there's a number of different submittal requirements when a permit comes in, one of which is a site plan that shows the proposed location of the structure, the size of the structure, and the setbacks to the applicable yards. And that's what I would review in the planning department for LDC review. And then the building department would review it for Florida Building Code safety requirements, and typically, like shed manufacturing specs that you purchase, if you buy a prefabricated shed, it will have those like specifications that show how it meets the Florida Building Code requirements.
Okay, thank you.
Your Honor, I do have a follow-up question because she specifically mentioned garage. So earlier, I'm not sure if you were in the room, I didn't see, but earlier, the city attorney argued that my interpretation of the land development code regarding needing properties, residential properties in Ormond Beach needing a garage, that somehow does not apply to me. Do you happen to know, first of all, would you agree with the fact that the land development code requires properties to have a garage?
Yes, so as our attorney mentioned, new builds that are required to have a garage, whether it's an attached garage, a detached garage, or a carport, some form of a garage with new builds. This particular neighborhood was built prior to the current land development code standards, so it could be exempt from that. We're not going to cite you for not having a garage, but if you were trying to build one going forward or do any form of expansion, we would talk about those processes and procedures at that point in time.
Okay.
If you're talking about,
Just
just one moment.
Okay.
And so if you're talking about a shed that's over 150 square feet, even if you're not using it as a garage, it's still defined as a detached garage because it's over 150 square feet. So you can have a 200 square foot shed in your backyard, and that is okay, it's subject to meeting the specific setbacks.
Okay, so you're saying that you guys, it's not so much that the land development code, and I'm asking what I understand and asking you to clarify. You're saying that it's not that the land development code doesn't require my property or my neighboring properties to have a garage. What you're saying is perhaps in a matter of fairness or something, that you guys aren't gonna walk around and, you know, knock on each door and say, hey, your house that was built in 1949 doesn't have a garage, and even though you're not trying to do anything to your property, we're gonna enforce this on you and make you build a garage. Is that what I'm hearing you say, is that it is applicable, but you're choosing not to unless the homeowner does something else to their property?
Well, not necessarily something that you do to your property. If you're trying to expand the like footprint of your house or something like that, then sometimes that will trigger certain things. Or say you had a garage already existing and you're trying to enclose it for living spaces, we wouldn't be able to permit that enclosure of that garage as living space until an alternative is provided. So I think that's maybe we're flipping the script a little bit, whereas you don't have a detached garage, you don't have an attached garage. We're not gonna hold you accountable for that. But if you had one and you're trying to enclose it, then you would need to provide an alternative going forward.
Well, my question is as to what's actually in the code. So are you saying it's in the code that I have to have a garage, and you guys are just not enforcing that part unless certain things are done on my side? Or are you saying the code does not require my property to have a garage? And that's what I'm trying to figure out. What are you saying that the code says?
I may be deferred to legal for clarification and direction on that.
The code does not require you to put a garage.
Do you know where it says that? No, not put a garage. The code requires my property to have a garage, and that sets off the trigger for all these other things before I can even apply for a permit. So can you please clarify perhaps where in the
I can do that another time, it's really a separate issue.
It's not, if I can't apply for a permit, then that's exactly the.
I don't think anyone has denied you.
Okay, this is getting where it's not helping me very much. Thank you for your testimony. Your excuse at this time. Did you say there are other?
There's one neighbor witness.
Okay, who is that? Come forward, please. Have your name, please.
Joan Conway?
Were you sworn to be at the beginning? When
Yes.
everyone else
Yes.
was? Okay. Where do you live?
I live at 9A Bayberry Court. It's directly behind their property.
Did you want to ask her questions?
No, I just let her speak to whatever she
Okay,
wants to speak.
what-
I brought plenty of pictures that I didn't have to go onto their property to obtain. And first and foremost, when I made the complaint, I understand that they needed my name and number to make the complaint.
Well, let me just back up. You
Sure.
made a complaint? See,
I'm the one that made the complaint
Oh,
against them,
okay.
correct. From a neighbor I heard a few days later, she was over taking pictures of our property, which is fine. Had a couple of run-ins with both of them. And the last run-in, I was told by Mrs. Henry that she knew it was me that made the complaint, and wait till I wait and see what's in store for me. I don't appreciate
Just talk
threats.
to me, don't.
Okay, I don't appreciate threats, because I went the legal way of reporting them, and was threatened by her. My daughter was there during this, but she's working and couldn't attend today. This has been going on since they bought the house. The fence is atrocious. Elena Village is a small neighborhood with cottages, is which they were built for. And the fence it's an eyesore. It brings down the 5 properties around it, their value. We now have a, light pollution, because they have lights on all over the house that go directly into our bedrooms in the back, sometimes working till after midnight.
Your Honor, I would object to the line of testimony that has nothing to do with the case that's called.
In a way, I'm gonna sustain the objection, for you to come and say that you were the one who made the initial complaint. That's fine for me to know. Usually, I know that now, but that other things probably doesn't help me in any way. Sustain.
She knows that these things aren't permitted, they're putting up a pergola now, that's not permitted, I'm sure. It's one thing after another.
Your Honor, I'm gonna object because the only thing she's offering is a bunch of baseless, factless hearsay that has nothing to do with the shipping containers at this point.
I'm probably not gonna go forward with that testimony, so I would sustain that objection.
So, all the complaints I have are relevant or irrelevant?
Your complaints are relevant, but I know what neighbors say when they come, but I don't need to go into details about it. It doesn't really help me in making my decision.
No, and I understand that. You know, this is a neighborhood of renters. If this was happening on John Anderson, those would have already been removed. There's just no doubt in my mind, because they're all homeowners. This is a neighborhood of renters that are not gonna stand up. They have no,
Your
they're
Honor,
not gonna
this is-
gain or,
I object because if, I have the right to be able to respond. She's talking now about a litany of other things that are baseless.
I
that
don't
can
want to
respond
get into that, but thank you for your testimony.
Thank you.
Okay. No, I'm not gonna
I think she
be
had some
cross-examined.
photos, I haven't seen the photos.
yes,
but
I have a bunch of photos. From the lights peering into our
If you want to
bedroom.
admit the photos into evidence,
Your Honor,
and then you object to them.
I do, because she's
Honestly, I don't know that I'm even gonna admit the photos into evidence.
I agree that that's my shipping container right there, so I don't see what else would be relevant.
All right, thanks.
Thank you, Your Honor.
Yeah. You have another neighbor or someone?
I don't think so.
Okay, all right, I'm ready to go to the third case. As the trier of fact, I can make a determination that I've heard all that I need to hear on a particular case. So that's what's gonna happen now, and I'm ready to go with, the third one.
Your Honor, just for clarification purposes, for what was put out there, I just wanna clarify that with that testimony, I didn't necessarily have a chance to question her myself, but what I do wanna say,
Well, it's because I stopped the testimony.
well, I understand that, but in her continuing to say things, I just wanna say that the things that she was putting out there as facts, supposedly us threatening her and all these other things, us ruining the aesthetic value of the neighborhood, everything else like that, it's not accurate, and it shouldn't have been something to be brought up. It's something that we certainly could have refuted with evidence and testimony ourselves. I just wanted to
Okay,
put that
well, I
on.
made my decision on that.
Yes, thank you, Your Honor.
The third one is, and it is case number 22-112247. The alleged violation is no building permit issued as stated in the Land Development Code for pavers installed without obtaining a permit. You can proceed.
My name is Janet Bruce, Neighborhood Improvement Officer for the City of Ormond Beach. The case before you is case number
Speak in the microphone.
22-112247. The respondent is Michael Henry and Katherine Henry. The violation address is 33 Cypress Circle. This is a violation of the Land Development Code, Chapter 1, Article 2, Section 1 through 14, 6A1, pavers installed without obtaining a permit. I would like to submit into evidence a copy of the notice of hearing and a $100 citation with proof of good service, copy of the notice of violation with proof of good service, affidavits for regular mail and posting, copy of property appraiser's record, and a copy of the Land Development Code that is at issue in this case.
Any objection? Your standard objection that you made earlier?
Yes, there's one additional thing, Your Honor, that I didn't catch if it was in the other ones, but it's in this packet. And just when it comes to as far as posting the notice, the way that it was said is that it was posting of lawful posting of notice, there's proof of that, and I would just specifically ask Your Honor to refer to my detailed summary that indicates how this was not a lawful posting of how they did that. I don't know if I raised that before.
You did before, and I recall it. It's omitted as a city exhibit, as a compliance.
Your Honor, I'm sorry, are you numbering these? Did you say this is 5?
That's one, isn't it?
Oh, because they're separate, I'm sorry.
I'd also like to submit into evidence copies of photos which led to the issuance of the notice of violation and the citation. Photo of the last status of the property which reflects the current state of the property, the recommendation as well as the case cost sheet.
Okay, take a look.
Just kind of look at my comparison.
Admitted into evidence as city's exhibit 2 as a composite. May proceed.
Your Honor, I just want to make sure that we're continuing my objection based on this.
The record should be noted on that.
Thank you, Your Honor.
These are photos that did begin on September 1st, 2022. It shows the pavers that are piled up as well as in the process of being laid down. I did speak with the property owner on September 2nd, 2022 and advised her that all of the work would need to cease to get a permit. I did also put on the stop work order the issue with the pavers that need a permit to proceed further with their construction.
Do you have a recommendation?
Yes, sir. This is October 25th, 2022.
No, the papers are all down now.
Now they're all down, yes, sir.
They're all down.
Yes, this is February 21st, 2023. The pavers are completely done. They installed 2 driveways and whatever they did in the backyard.
If a permit had been obtained for these papers that are down, do you have any comment on whether they would have been allowable?
If they had received a permit, I'm not sure what planning and zoning would have stated. However, the setbacks are probably not being met right now. The pavers are going to the property line. So they most likely could get a permit. However, they would have to do everything that the inspector tells them needs to be done, whether some of it needs to be removed to meet setbacks, whether they need to see what's underneath the pavers to determine if it's been built correctly.
All right, do you have a recommendation?
I recommend finding that a violation of the Land Development Code, Chapter 1, Article 2, Section 1-14-6A1 exists, and that the respondents be ordered to pay the $100 citation as well as the associated case costs and shall comply with the code by March 27, 2023. Compliance shall be achieved by obtaining an approved permit for the pavers and meet all setbacks required for the pavers. Absent compliance, I recommend a $25 per day fine be imposed beginning on March 28, 2023 and shall continue to accrue until compliance has been achieved. Further, the respondents shall be obligated to contact the City of Ormond Beach Neighborhood Improvement Division to schedule a reinspection of the property to confirm compliance and date thereof. Case cost is $23.56.
Good. Okay, your turn to argue on this particular case about the papers.
Yes, Your Honor, I actually have, I'd like to start in the form of question to
Okay.
Janet Bruce about this.
To the inspector.
Whatever your title, what's your title?
Inspector.
Oh, okay, then yes, you. I apologize, I didn't know the title. I'm going to reference, I believe it's on page 2 of the exhibit 2, specifically for this case. Easiest to note by the picture I'm talking about specifically has the hurricane debris from palm trees and things like that sitting in the front. So that's the picture I'm talking about. It's at the bottom of page 2. And I'm not sure.
Are we into it, this one?
Yes. So the, I'm not sure if you could tell on your screen any better. My black and white copy that I was handed doesn't really show, but, so my question is about, and you've been there, so you obviously know better than what the picture would show, but the driveway that was originally paved is, essentially the pavers have like an L shape around that driveway. Would you agree?
Yes.
Okay. And so the, what you're saying is, I wish that was a little bit shorter to the ground so I can point, but, the,
We have a pointer, a laser pointer.
do you? Oh,
Because I'm not that tall.
6 foot
It's-
9.
Okay, thank you.
at either one would work? Does it have to be pointed at
It
one?
doesn't.
Oh, it's not tied to the device. Okay, so, let's see if I,
Turn it around.
Turn it around.
Turn it around.
Yeah.
okay, so can you guys see where I'm pointing? Just wanna make sure I'm doing this okay. There's a line right here, and so right here, I'm outlining the side. Were you able to see that, Your Honor, that, that's the portion I'm talking about? Or do you need me to further explain that?
That's it.
Okay. So, my understanding from what you just said, when he asked you about the setbacks, is that you were saying from this line over to the property line, that there has to be 7.5 feet of, where there's nothing, I guess. Is that what you, is that a correct
Yeah,
statement?
You might want to refer just Sarah. to
Yes,
the
that's
planning
a-
question.
That's a question for Sarah.
Good afternoon, Sarah Cushing with the
Okay,
planning
make
department.
your answers short.
Okay. So with driveways, those are a different accessory structure that are subject to different setbacks. At the property line, the driveway has to be 3 feet back from that side property line. So if the leading edge of that right now is on the property line, it would have to come in 3 feet in order to comply with the land development code.
And where does it say 3 feet? I've always been told by them it was 7.5.
Well, this section is section 3-25 in our driveway and access standards. Specifically, item C, driveway standards number 1. Thank you.
Your Honor, I just need a moment. That's the first time I've heard of that one. I don't know if this would be a question for either one of them. It doesn't matter to me, but, based on the documentation I've already submitted showing that, I would be held, at least by somebody in the city, to a 7.5 feet setback. My question is about clarifying that when pavers or any kind of concrete is poured or anything that's to enlarge a driveway, whether that has to be then, my understanding is that you cannot build it this way going towards the center of the property, that you can only place those going away from the house and toward the side property line based on the land development code. So again, I'm not sure which one of them would be,
Okay, what's the question?
if that's correct,
Okay.
that you have
Yeah,
to build it.
Can you answer that question?
Of course. So you can definitely build to the left. You really would be more encouraged to build towards the left-hand side of the property, but you have to stop at that 3-foot setback.
So is it correct though in saying that if I tried to put pavers to park right here, that is prohibited under the land development code?
It really depends on the scope of the work, and if we were to look at that together, I would be able to provide some more guidance.
Sure, I think these would be great questions during a permit process.
Your Honor, I'm just gonna tell you that it's actually prohibited from building towards the center of the property. And you have to go out, and it actually does say in there 7.5 feet, but then since it goes to the impossibility, I have to lay pavers that go towards the side property line, but then I cannot lay pavers supposedly that are within 7.5 feet of the property line, and it creates an impossibility to have any kind of extension of parking, and yet I can't park on grass there's a land development code in the same provisions about parking that says you cannot park on grass or dirt or stone. And so, like the city attorney's office that has dirt and grass and stone and mulch as their parking area, that's a violation of the land development code. So no matter how I do things, my point is that it's an impossibility to meet all of these and be able to reasonably use my property. The pavers are not encroaching upon the other property. It's not changing the drainage or runoff, other than we worked with the neighbor over there where it shows right here that there's a little bit of sand. That's because his property had a little bit of a dip right there before, and then certainly was exacerbated by the hurricanes. So when I talked to him one day when he was out repairing some hurricane damage on the south end fascia of the property he owns right there, I was able to, I asked him if he wanted me to fill that in with a little bit of extra dirt that we had, to which he indicated yes. So at any rate, other than that, making it better.
I'm sorry, I was talking to my clerk a minute.
Okay, sorry, I didn't catch that if I interrupted you. Other than making it better, this little tiny patch where we asked him if he wanted us to help him out with that, we did not, there's no negative impact. We're not changing, putting more drainage onto neighboring properties. We're not doing anything other than making sure we have less sandspurs, since we can't grow grass here without significant irrigation, which is another thing that's protected by Florida statutes. We have, overall with all of these, we have wind mitigation and flood mitigation methods being used, and those are specifically protected by Florida statutes. And I believe I might have a case. I didn't know you'd be wanting cases when I had statutes, but
Sure.
I believe I might have a case if you wanted me to double check that that case speaks to the point that I just made about
Okay.
when you have a Florida statute like that that's specifically calling for those kinds of measures to be made on private property. You want me to look to see if that is your honor?
Sure.
I think I have it. I just want to make sure that I'm not misleading you, Your Honor. Okay. This particular one I brought with me, like I said, I wasn't prepared knowing that you would want cases at an informal hearing. But this particular one is actually City of Ormond Beach versus Del Marco, I think how it'd be referred to, short citation. It was in the 5th District Court of Appeals from 1983 and still serves as good case precedent to date. And it's talking about a different statute. This is in terms of constructing or maintaining renewable energy sources, but it's saying that the city cannot restrict or prohibit construction or maintenance of a renewable energy source. And I can continue there, but my analogy would be, Your Honor, when the state has made it perfectly clear that they want certain things being done to essentially benefit everyone, such as encouraging sustainable energy use sources, encouraging wind and flood mitigation when we obviously live in an area where hurricanes happen and things of that nature. The state, which I have laid out very specifically, and can go into more specifics verbally if you'd like, but they've made it very clear that no municipality, there's even a statute I cited specifically to that, no municipality can regulate or get in the way of, stop somebody from employing flood mitigation techniques or wind mitigation techniques, from stopping the use of installing things like pavers or rocks instead of having to turn to extensive irrigation in order to simply grow grass, which is what the areas that we're talking about. You can see from the rest of my front yard, it just doesn't grow grass. It's all it is weeds. The only green that you see there is actually just a piece of turf that a neighbor had. And I'm using it to stop the weeds from growing right now until we figure out what else we can do. But that would be my concern. I can, this is the only copy I brought with me. If you want me to present this to you, I can.
Let me glance at it right now. Then I'll give it back to you.
Did you want me to highlight the holding portion? Because I can do that.
No, let me just, from what you said. Okay, I'll give it back to you. Okay, we're going to need to wind up here. Do you have any response to our arguments on this particular case?
On that particular case citation, no.
Yeah.
I just would say that it has absolutely no.
Anything else?
Yes, Your Honor, I just wanted to circle back.
Do a summary for me.
Yes, Your
You've
Honor.
already made the recommendations.
May I speak to counsel?
Yeah.
Sorry. I do, Your Honor. I was just gonna, I'm assuming you want me to wait.
Okay, I need you to, you have not made your recommendations on this third case, so I need you to do that at this time.
I recommend finding that a violation of the Land Development Code, Chapter 1, Article 2, Section 1 through 14, 6A1 exists, and that the respondents be ordered to pay the $100 citation as well as the associated case costs and comply with the code by March 27, 2023. Compliance shall be achieved by obtaining an approved permit for the pavers and pass a final inspection, or to remove the pavers from the property. Absent compliance, I recommend a $25 per day fine be imposed beginning on March 28, 2023, and shall continue to accrue until compliance has been achieved. Further, the respondent shall be obligated to contact the City of Ormond Beach Neighborhood Improvement Division to schedule a reinspection of the property to confirm compliance and date thereof. Absent compliance, I request that the city be granted the authority to enter onto the property on or after April 10, 2023, and have the right to remove the unpermitted pavers from the property with all costs thereof to be assessed against the respondent. In addition, should the city remove and dispose the aforementioned pavers, the city shall not be responsible for any damage or loss associated with said removal.
You did not go to the second page. You look at the
It's
second
not,
page.
it's not on this one, but it is in your packet, Your Honor.
It is in your packet, my packet?
Yes. We have a second.
Okay. All right, thank you. Ms. Henry, we're going to sum up, and I'm gonna let you have the last word. And then I'll let the city respond to it, and Judge, we will finish with the hearing today. And I will be, asking all of you to leave, and I will sit here with my clerk, and then I'll make my decisions on the case, and then call you back in after about 10 minutes. So, what else would you like to tell me?
Yes, Your Honor. What I want to point out, some things that I alluded to before, but you had asked me for some more examples. So, in looking at the totality of all three of these, our state constitution, to which everyone here has sworn an oath to uphold and defend, we have Article 1, Section 23, the right of privacy, that we have the right to be free and let alone from government intrusion into our personal lives. Specifically, you asked about a case. The application of a general zoning law to a particular property affects a taking if the ordinance does not substantially advance legitimate state interests, and not once have they talked about any legitimate state interests that are being furthered, let alone substantially, by trying to have my shipping containers removed and removing or changing out my fence and at least tearing up my pavers to see if they were done correctly, any of those situations. Several state laws specifically protect a homeowner's property rights against this very kind of overregulation. Just some examples would be Florida Statutes 187.101, 163.3194 subdivision 4, Florida Statute 70.001. If you look at 163.31776I, it requires local governments to consider constitutionally protected property rights in local decision-making, including this very proceeding. This is the kind of proceeding where we have to remember, no matter the specifics and not get lost in all the details of setbacks or things of that nature, that beyond it all, or underlying it all, is that we have constitutionally protected property rights that are also statutorily protected property rights. Florida Statute 163.3161 requires that ordinances and regulations be implemented and applied specifically with sensitivity for private property rights and not be unduly restrictive. And property owners must be free from actions by others that would harm their property or would otherwise constitute an inordinate burden on property rights. And Your Honor, what I had tried to make exceedingly clear in my printed versions as well as in questioning and statements today to you was that it is an inordinate burden to try to do these things, where I'm required to have certain parking areas to be a certain material. It can't be grass, it can't be this, it can't be that, but it has to be built out away from the center line of the home, but it can't be within a certain amount of feet from the property line. It's physically impossible to do a lot of the things that they're saying to do. Even to have, we're legally required under the Land Development Code, there is no exception or grandfathering in for older properties. As we heard in the clarifications, it's just more of a, in the interest of justice, they decide not to go after people who don't have garages, but it's currently written that you have to have a garage, and in order to have, apply for a permit to have a garage sale, to put up a fence, to do anything, you have to have a full variance approval, you have to meet all these other specifics in order to even apply for a permit. And in the end, we had the main argument that I heard from the city attorney today was that, oh, these are great questions, these are things that would be good and fine to do at some other proceeding, but underlying all of this, I am guaranteed a fundamental right of due process, and any kind of confusion or unclarity on any of these points, the Supreme Court has clearly stated for 100 years now, has to be resolved against the city, not against the private property owner who is causing no harm to anyone around her. If somebody doesn't like the look of something on my property, that's not harm. That's their own personal opinion. So, Your Honor, I would ask that you also keep in mind that if you look at the 11 violations that I had prepared to you, demonstrated to you of extensive remodeling and repairs that were done just in the sample neighborhood that I showed you, 6 were specific fences to fences being built. 1 was about parking, pavers and parking areas. 5 were about sheds or shipping container type of situations. All of those were specifically recently done and in my small little neighborhood, and they were done all without permits. And I also submitted evidence to you that the city knew at least about some of them, specifically with the fence and the stone being put where law enforcement is currently parking on a regular basis, and permits for other things have been issued, so the city has been out there. But 457 examples just in my tiny little area, a quarter mile from my house, where there's other paver violations and requirements not being enforced. 266 other examples for shipping containers, sheds, structure requirements. There's 3 different areas where there's actually shipping containers that have left to be there for far more than 30 days and have no problem, both in residential and commercial areas. Fence land development code requirements are not being enforced at least 63 other properties just within a quarter mile from my house. And the fact that government officials are getting a free pass even just within my small little sampling. Ormond Beach Police Department officers, Volusia County Sheriff's deputies, Ormond Beach City employees, the City Attorney's Office, Volusia County Council and former Ormond Beach Commissioner residences, Florida State law enforcement personnel, you name it. There's examples of these very things that are supposedly violations that are not being enforced. And it's one thing to say, oh, well, you know, I was speeding and you know, I got pulled out and I was the only one that was speeding, versus to show you that there are just of these types of violations, just from what I can see, 810 within a quarter mile radius. And if you extrapolate that out to the square footage within the city of Ormond Beach, that means there's over 115,000 similar supposed violations that the city is doing nothing about. You take a look at that versus how they did not follow the law, even on simple things of how to serve me for the hearing for today, or not following the law on 70.45, or a host of other things that I meticulously detailed in the submission to you. It shows that this has been personal for quite some time. I don't know why. I don't know why they've made it personal, but they have. And that kind of selective enforcement has and always will be unconstitutional, and it's illegal. Not to mention the impossibility of being able to even ask for a permit in these situations because of the things I mentioned earlier. So, Your Honor, I'm just asking you to follow the Constitution, to follow state law, and even the definitions of the very land development code that indicate clearly that my fence is not covered in the statutes or the land development portions they're saying it is. My shipping containers are not covered in the codes that they were generally referencing, and nor are my pavers supposed to be removed given the actual language of the code. So with that, Your Honor, that's all I would ask you to do today.
Yes, Your Honor, all 3 of these cases come down simply to failure to obtain a permit. we spent several hours here this morning, all of which could have been avoided, and a lot of time and expense on behalf of respondents. Had they gone through the simple process of sitting down with one of our planning, one of our city planners to go through these things, and could save a lot of time and money. The respondents talk a lot about their rights and their rights to do with what they want on the property, but I think she said herself that regardless of other people's rights around her and how they think it may look, that doesn't matter. That's not a concern, but I suspect one of the reasons why she probably moved to Ormond Beach is because of the way it appears in the nice community that we try to protect. I do want to mention the recommendations, the orders. Two of the orders asked her to go ahead and get a permit for the pavers and the fence. Doesn't mean she might not have to make some modifications to those if they don't meet the setbacks or height requirements or materials. We don't know that because we don't have the information. Part of the requirement is to do that. We have not asked that, and that's the typo on the shipping containers. We mentioned twice, chapter 2, article 3, section 2-5, and it really, the second one should be deleted. It's just,
Is that in the recommendation?
it's in the recommendation.
Can we go back to it? Any way I could look at this?
But the reason why, Your Honor, we're not ordering her to get, to go through the permit process is she's certainly welcome to do that. If she wants to try to get a permit for those shipping containers, she can make application and she can pay the permit fee. But we don't like to order that, Your Honor, because shipping containers, cargo shipping containers are not gonna be permitted in this residential zones. Therefore, we didn't want to order her to do that.
Okay, well, where do you say that?
Okay,
I'm looking at it now.
Right, where up above, we say chapter 2, article 3, section 2-50A9, that's failure to obtain a permit, and we repeat that citation down below, and we just should strike that second citation reference. It's the same reference.
Still, I'm looking, okay, all right, okay.
And that's all. Thank you.
Okay, thank you, folks. I'm gonna ask everyone to take a break, and if you'll go